with roll call and determination of quorum. Thank you. Now for the adoption of the agenda. We have a motion to approve and a second. All in favor? Aye. All opposed? Motion passes. Now on to general public comment. I have none, so I will open and close general public comment. And we'll move on to consent items 1 through 13, and I will open public comment on that. I have no public comment, so I will close that, and I will ask the committee if there's any items they want to pull, item 1 through 13. If not, I'm looking for a motion. Alderwoman Scott, you have the floor.
Thank you, Mr. Chair. I was looking for Barb Garcia, and I do not see her in the audience.
There's Ray back there.
Okay, so thank you. So I'd like to pull item number 9, please.
Thank you. Mr. Lorente.
Item 12, please.
Thank you. It looks like there's nobody else in the queue, so I will look for a motion for items 1 through 13, except for item 9 and item 12.
Second.
We have a motion to approve and a second. All in favor?
Aye.
All opposed? We will move on to item number 9, approve amended resident participation plan. And Alderwoman Scott, you have the floor.
Thank you. And may the representative from Barb Garcia's office approach the podium. And I'm sorry, I haven't met you yet, so if you could state your name and your affiliation to the city. Thank you. And Mr. Chair, may I ask her a couple questions?
You may. Either her mic's not on or she's not close enough to her mic.
Can you hear me better? Okay.
Thank you. So the reason I pulled this is that it's really a nice short title, but if you could give us some idea of what this actually is.
It's our amended plan. It was the Citizen Participation Plan for the Community Development Block Grant. It's been updated. We had to update it per HUD regulations. So we've added a few bits and pieces basically to partnership with public housing agencies to make sure we're collaborating with them, that we have support, all that fun stuff so that they succeed. A few other items have been updated, but basically it's still that same Citizen Participation Plan renamed per HUD.
All right. So, and then from my understanding, what this really involved was there was some also language changed as far as the grant itself from the federal level.
Do you mean within the plan itself?
Yes.
Yes, some language has changed within there, like just renaming the plan.
So this really just brings us back into compliance with
Yes.
so that it can support the CD, Community Development Grant.
Yes.
All right. I'd rather say it out because I get it wrong every single time when I try to use the acronym. Thank you very much. I can support this.
Thank you, Ray. We're done with you. And do we have a motion on the floor?
So moved. So moved.
Second.
We have a motion and a second. All in favor?
Aye.
All opposed? Motion passes. Item 12, authorize mayor and finance officer to sign professional services agreement with Walker Planning Consultants for the downtown parking study and strategic plan in an amount not to exceed $95,000. And Mr. Lorente. Okay. We need a motion on it.
Second.
We have a motion to approve and a second. All in favor?
Aye.
All opposed? No. Motion carries. On to non-consent items, items 14 through 16. I will open public comment. I don't have any speaker requests for them, so I will close it. We'll move on to mayor's items, items 14, approve.
13.
Item 14, mayor's items, Approve Resolution 2017-056, a resolution declaring lots 1 through 12, Block 19, original Town of Rapid City surplus, and appointing freeholders to appraise the property. I need a motion. Alderwoman Scott, you have the floor.
Thank you, Mr. Chair. May I ask a couple clarifying questions to our city attorney since the mayor's not here?
You may.
Thank you. So, Joel, my understanding on this is really before the city can do anything with property that the city owns, and this was originally purchased to benefit the Parks and Recs Department for the potential site of a recreation center or something. So now that it's no longer needed because we've got Roosevelt Park in place, the city would have to go through these steps to declare it surplus and then get an actual appraisal so we know the value of it. Is that correct? That's what this is?
Yes, that's correct.
Thank you. I'm done.
Thank you. Still need a motion. We have a motion to approve and a second. All in favor? Aye. All opposed? Motion passes. Item 15 from the City Attorney's Office, introduction and first reading of ordinance number 6186, an ordinance to amend provisions concerning appeals to the Building Board of Appeals by amending sections 15.04.120 and 15.04.130 of the Rapid City Municipal Code. And Alderwoman Scott, you have the floor.
Thank you, Mr. Chair. May I also ask a couple clarifying questions of our city attorney, please?
You may.
Thank you. So, Joel, this is just being brought forward to kind of streamline, from what I understand, just to streamline the proceedings at the Building Board of Appeals because it's kind of getting off track. Oh, I see Carla's approaching. Would you rather have Carla?
Yeah, I'll defer Carla's work directly on this, and so I would defer to any questions to her.
Thanks. So, Carla, my understanding is really this is just trying to clean up and stream what is actually anticipated to be brought before the Building Code of Appeals Board because it's kind of getting away from what the Building Code of Appeals is supposed to be handling.
Well, this doesn't, that's true in some, that's true generally. It's not that the building board is getting a huge amount of complaining people about their contractors. This happened, actually the number of complaints that they get that relate to the changes were some time ago, maybe 2 years ago. But it is limiting clarifying the language so that not anybody who has any sort of complaint with their contractor or a contractor has a right to appeal it to the building board, that they need to take that up with Brad, our building official, and the community planning department, and that's their mechanism. It still allows an appeal if we're talking about taking away somebody's business license. They have an appeal to the building board. If you're talking about a decision from the building official to revoke a license, that still remains in place. And there's other roles of the Building Board of Appeals to have those kinds of appeals, but it is clarifying who has the right to make an appeal to the building board.
Thank you.
Alderman Laurenti, you have the floor.
Thank you, Chair. I'd also like to ask a question of the Attorney's Office, if I may.
You may.
My question for you is kind of a follow-up, but I just want to make sure that I have the process right, because I want to make sure that residents still have an opportunity to lodge their complaints, because if the council remembers, at least most all of us, we've had some issues with roofing. I think there were some roofing issues we had where people, and this was to the Building Board of Appeals, on some roofing jobs that were at issue, and when those licenses were issued, and I can't remember all of the details. However, my question to you is for residents. What's the process for a resident if we change this?
The process for a resident at the city would be to make a complaint to the building official. He ultimately is the one who issues the licenses, and under the ordinance, he can revoke them or suspend them. And so that would be their mechanism to address those kinds of complaints. They would have additional civil remedies outside of the city, and the cases that we were involved with that I think you're referring to did involve also lawsuits. And so this was a situation where the city kind of got wrapped up in a contractor-homeowner complaint in a way that the city was kind of being asked to be a tool outside of that system. So that was the situation previously.
Okay, so my question then is, the resident goes to the building official to lodge whatever grievance they may have. Is there anything that in the process for the building official to verify this grievance, and then is there a communication between the building official and the Building Board of Appeals when it comes to licenses, as far as individual contractors who have, say, let's just say they have multiple grievances that are valid, we don't even know. So that's my first question. Is there anything that validates a resident's grievance with the building official? If that's the process that we want the resident to take, is there anything that validates their grievance with the building official? Is there a process?
I think the building official looks into the issue, talks to the contractor, talks to the complaining people, and makes a decision related to the license. So there is an investigation that, or some level of investigation that takes place.
So from there, is there something then in the process that gets the building official to document these grievances so that those can then be communicated to the Building Board of Appeals, so that there's a good decision made by the Building Board of Appeals when it comes to renewing licenses? Because if there isn't a link, we've got a problem.
Well, there's not something that's dictated by ordinance, but there is communication between the building official and the Building Board of Appeals related to status of licenses, when there's action taken against the licenses. I've seen it where the Building Board of Appeals brings, this happened just most recently at their meeting, brought an issue related to a contractor to Brad's attention that then he was aware of it, but it prompted more investigation. So in terms of a formal link between these kind of things, it's not formally written in the ordinance, but on a practical level it occurs.
Well, I'm not comfortable with that. I mean, where's the protection for the residents when it comes to a contractor? I'm not saying that we have contractors like this, but we surely could, especially ones that aren't here. I don't want to say that may not be true, but if we have a contractor who is out doing things and there isn't some formal link between the resident's ability to lodge that complaint and then that complaint be documented so that when that contractor's license comes back up for renewal, there's no link, there's nothing in the process then that documents that it just might be hearsay. Oh, do you remember, you know what I mean? So I'm a little uncomfortable with doing this without there being a link and a route for the resident to lodge the complaint, have it validated, and somehow be part of the future decision, especially if there is a problematic issue with a contractor, because otherwise the Building Board of Appeals just approves it because, well, unless the building official brings it up. That's what you're saying to me, right?
Well, actually, it's not the Building Board of Appeals that issues licenses. It's the building official. And then any sort of dispute goes up to the building board.
Right.
So I can't speak for Brad. Oh, he's right over there. But I think this is part of the decision-making when the issues come up, or when the licenses are renewed, or when a new license is issued.
Okay, so what does the Building Board of Appeals hear if it's not residential or resident complaints?
They make decisions related to the ordinances. In fact, there's an ordinance coming up that, this is the ordinance. They review appeals for suspended or revoked licenses. So if you have a license and Brad takes it away for a permanent or temporary basis, that can be appealed. That's an important appeal related to due process, so that's retained. There's decisions made related to alternative materials or alternative methods, those kind of details of the building code. If they're unsatisfied with the decision that's made at the level of the building official, they can appeal it to the professionals on the board.
And so these examples you're giving me are all ones where there's a nice documented process. Am I correct in that, what I just said? These things that the the Building Board of Appeals actually hears are things that are fairly well documented. There's a process for those. The problem I'm having is for residents who have complaints, it might be hearsay that the building official tells the Building Board of Appeals that there's been multiple issues. And I'm not saying that we want to go back to the issues we had before, because I don't want us to intervene where litigation needs to happen from a private standpoint. All I want to do is make sure that a residential grievance is validated or not. I don't know if it needs to be validated, because then we're kind of stepping into an area there. But I would love to see a process where, in my opinion, we're cutting out residents and their complaints, and we're not weighing their complaints at all in the renewal of a potentially bad contractor, unless I'm not hearing this right, because I'm just wondering, I feel like the residents are being cut out of the process of a contractor getting that license renewed.
Well, I would just say there's a lot of record-keeping things we do that aren't required by ordinance. And I mean, in order to properly document it, we should probably, I'm not trying to suggest we shouldn't be documenting these and have it in place. You know, one of the difficulties is, and what we found with these is, it puts the building board and ultimately you, a lot of these have ended up in front of the city council as a fact finder, and you're not really set up to be fact finders in these situations. And people are using this as an avenue to try to gain leverage on a contractor, and, you know, versus taking a legal course of action, because they have other remedies and courses of action. And, you know, let's be honest, everybody makes a mistake or things happen. So, you know, it's difficult sometimes when maybe there's a legitimate concern, but the building official looks at it, there's a reasonable explanation, the contractor is willing to fix it or whatever, and there's no reason to take any further action. Yeah, if you get 10 complaints about the same guy and they're all very similar, maybe that's a level of concern that would cause the building official to, you know, take action against that license. So, you know, he's going to need to have some documentation for that, and we should probably have a discussion about an internal policy as far as how we're going to document that on this. On the other hand, if you're a contractor and somebody files a complaint and the building official looks at it and it's not really substantiated, or it appears it's not that serious, and then it gets thrown in a file and then it gets brought up again and it's 2 years later, and the contractor is going to say, hey, wait a minute, how am I supposed to defend myself against this? So, you know, we have to give that some more thought.
Agreed.
However we do it, I don't know that I think it should be in the ordinance.
Okay.
The problem we have is that we've had a couple situations where it appears homeowners who were legitimately upset and may have had reason to, but we're using this process to try to achieve a result that really wasn't the purpose for the building board. I mean, the building board is really, if the building official makes a decision, an administrative decision, like I'm not going to grant a license, or, you know, a lot of things with the building code, they want an exception from one of the requirements or an alternative means or method, and the person that's making that request disagrees with it. The building code is experts in the field who then the appeal is made to, and they look at that and they make a decision. And that is why the decision was made. Yes, there is a potential. It gives the citizen maybe one less avenue, but they can still complain about it. They still have legal remedies if there was a problem with their job site or their house or their construction or whatever the case may be. But, you know, what tended to happen is the building official would look at it and maybe even if there was an issue, say, well, I'm not going to suspend their license, or I'm not going to take any further action because I have no evidence that this person, you know, everybody makes mistakes and that this is worthy of having license revoked. And people would say, well, I'm not satisfied with that. And then they'd appeal it to there, and then the building official or the building board would affirm it. And then they'd come to you and say, oh, and we're trying to just nip that in the bud where that process isn't being abused.
So when we're issuing these licenses, so I'm saying is, let's say a private individual takes a contractor to court, wins, there's fraud or there's something that happens that this person now has. Does that individual contractor have a record that shows up when they apply for a license? Do we look for these kinds of things where they've been convicted of something in private litigation? Is that looked at from a licensing standpoint?
I'm pretty confident we don't go review the court records to see who has gotten judgments against them or,
Well, I'm saying criminal backgrounds. I'm saying
well, I would defer to Brad on that. I don't know that we do criminal backgrounds, or we may do it initially, but whether we do it at every renewal.
not even initially, Brad? Okay.
Well, you got to be careful too, because again, we had a licensing issue the other night where
Right, that's
somebody
why I'm
had a
saying-
potential criminal, and it was like, well, does that exclude them? If you have 3 DUIs, are you excluded from being a residential contractor? I
Right.
mean,
Yeah, no, and I agree. I'm saying where the crime is pertinent to the license that they are applying for, which is different than what we were dealing with the other night. So, but I'm saying when we have licenses where they're applying to become a contractor to do work on residential homes, they've been convicted of crimes related to that very same thing. So if we're not even, I'm just saying we require background checks on quite a few different positions.
and I could see obviously if somebody is convicted of fraud or something within 2 years. But now it seems like we're kind of going down 2 separate issues. One is an appeal process and what should be appealed. Now the other is, well, maybe this has caused us to look, do we have our licensing requirements? So if I could make a suggestion, maybe we proceed with the appeal, but then staff separately looks at the licensing in general and what we require, and could maybe at a later meeting bring back a report. And if you're not satisfied with the process or the licensing requirements, then we could address that.
Very good. I just wanted to make sure that that there's some avenue, and I agree. I think ultimately it does not need to be in this process, so I agree with that. However, as we're cutting them out of this process, the other process doesn't capture private litigation, which is what we're saying the reason why we need to make this change is because private litigation is a process to do these types of things. But if we're not going to look at people who are convicted of private litigation for things that are directly related to a license that they're applying for, well, however, then they are now being completely cut out of the process. So, but I agree, we need to come back with probably the other process to correct that. So I yield. Thank you.
Thank you, Mr. Lorente. Alderman Wright, you have the floor.
All I can do is share a little advice. My last time. I think that it's most important. I hear the word talk. I hear the word refer to whatever, but I think the most important thing in all of these issues is that the decisions by the building official be in a documented form, preferably by letter, with a date, time, signature, and source of, that's put in the file. And it's concluded and shared with all parties, so that everybody does have that history. If we're relying upon memory, or I said, very dangerous place to be and not fair, number one. Number two, the issue, as I recall, that was before us and caused us a great deal of pain and time, I would say, at least for me, was for the roofing contractors, where we were issuing permits and really not following up with inspection. Let's make sure that if we issue a permit or we're involved with licensing or anything, that we have, in effect, the process to assure that they're in compliance with our requirements. If we're not, we shouldn't be issuing the license or the permit. I think that we had the drill of several years ago where the people were paying for roofing license, or excuse me, permit, and really no inspection was occurring. Create a lot of problems. So I'm just sharing with you those 2 comments. Number one, everything should be documented by letter, in my opinion, not by phone, not by email, but something that's got a date, time, source, and a signature on it, clearly written. And the other thing is, if we're going to issue a permit that has an issue related to requiring to meet minimum standards or whatever, that we assure that that happens. Thank you.
Thank you, Mr. Wright. Alderwoman Scott, you have the floor.
I'd like to make a motion to approve and retain the floor.
Second.
Yes.
And thank you, I just wanted an additional comment. Thank you for the discussion. I think it's been good.
Thank you. So we have a motion on the floor. All in favor? Aye. All opposed? Motion passes. Item 16, introduction and first reading of ordinance number 6188, an ordinance to update requirements for purchases by amending section 3.04.030 of the Rapid City Municipal Code. And Alderwoman Scott, you have the floor.
Thank you, Mr. Chair. I'd like to make a motion to approve and retain the floor.
You may.
Thank you, and I believe I can ask our Chief Financial Officer a question if you'll allow me to. Thank you. Pauline, I may have confused this one with the other item that I was asking about the community block grant. Is this the one that updates based on grants and how the grant tracking has to be tracked, verified?
This one has to do with purchasing product through a grant reimbursement process, making sure that we're following their requirements under the uniform grant documentation requirements that they have.
Thank you. I think I was getting the two of them intermingled with each other. So the residential program that we were talking about earlier is changing language and requirements based on HUD. This is the one that is actually referring to and updating the city's policies and practices as far as purchasing and tracking those purchases, because there's more restrictive tracking that's needed for grants. Is that correct?
That is correct. An example that I give is right now our ordinance requires that we get quotes for $5,000 to the bid limit. They require $3,500 where we get quotes. So we just want to make sure that our policies match what are required of our federal grant requirements.
Thank you. Thank you for that explanation. I yield the floor.
Thank you. No one else in the queue, so we have a motion on the floor. All in favor? Aye. All opposed? Motion passes. Does anybody want to adjourn the meeting? Oh, you won't. Sorry, go ahead, Amanda.
Thank you, Mr. Chair. If you would hold that just a second. If I may take a minute?
You may.
Thank you. I don't know if everybody's aware, but I would hope that you are, based on city business. We just completed the city elections, and this happens to be the last meeting that Jerry Wright will be joining us for Legal and Finance. We will be sitting new council members on Monday night. So I don't know if I can speak on behalf of all the council members, but I would like to offer my heartfelt privilege and honor of serving with you, Jerry, for the last few years. The one thing I know that I personally will miss, even though you get teased a lot about it, is you do have the historical perspective, and I truly will miss it. Although sometimes I will roll my eyes when you start down your path, I truly will miss that because it has been very, very valuable. So I just wanted to take a minute and thank you, Mr. Chair. Jerry, good luck in your adventures. Thank you.
Very much. What a privilege and an honor. Move to adjourn.
We have a motion to adjourn and a second. All in favor? Aye. All opposed? We're adjourned.